Let's kick off. Ian, this is right up your alley. And we're going to talk about estate claims. Do you have any opening remarks?
I think, as you just mentioned, today, just let's talk in terms of from a non-litigator perspective. So we don't want to get too granular on it, but I think it's a real skill set to be able to add value to your client relationship with estate planning when you can at least identify some of the parameters of which claims will be made and the types of steps that might be taken. It really helps inform a client if you're trying to direct decision making and on the basis of certain things, like what could happen, as opposed to that. And for today, let's just try to get through some of the, obviously this, we could take hours and hours of discussions on the various claims, but today we want to just start to cover off what we should be watching for to help assist our client.
Great. So the agenda for today is basically what types of claims you might see, and we'll probably add to the list as we go along. The authority of an executor to sue and how to sue an estate. Some special defenses that are only available to estates and that we wanted to highlight, and then just how litigation expenses might be dealt with in an estate. And we're not talking about challenges to wills here. We're talking about claims made where the estate is either a plaintiff or a defendant. So I'll just take the first one, and maybe Ian, you can take the next few there.
Sure.
So the first one is the typical, claims against estates for debts, an amount owing by the deceased to someone for something, breach of contract, even failure to pay something. We're going to talk a little bit more about other constructive trust claims, but that's sort of your typical common debt claims for against estates. Ian, maybe talk just a little bit about constructive trust and resulting trust claims that you might see against an estate.
Sure. And I think that's where, as I was saying before, we want to just talk in terms of general concepts. A constructive trust and a resulting trust are claims that can be made which may be a surprise to your client, and that they're the type of claims that may not be entirely intuitive. A constructive trust claim, of course, is as a consequence of behavior or conduct on the part of parties. The classic was set out by the Supreme Court of Canada in the trilogy of cases back in the 70s and early 80s with Peckus and Becker and so forth, where the court had to look to a remedy to adjust for unjust enrichment, where someone was unjustly enriched, where in those days where the spouses were being treated in a fashion that on marriage breakdown or on death, they weren't getting their fair share of the wealth. And so the court imposed a constructive trust, a legal construct over the assets, and said, indeed, though your legal title was in the name of the husband in those days, the wife has a claim as against that as a consequence of you holding it in trust. And a resulting trust is slightly different, but at a high level, we've talked about resulting trusts for lots of times. The Pecori decision of the Supreme Court of Canada talked about it and set it out. Same idea is that what you're looking at are situations where claims may exist which you may not have anticipated as a lay person. And so I like to just go through these two concepts with the clients generally.
Dependent support, and we're going to talk a little bit more about dependent support, just what to do if you're acting on an estate rather than when you're bringing a dependent support, which is a different kind of discussion for another day. And Family Law Act equalizations. Do you want to just briefly touch on that, Ian?
Sure. Just to remind our clients at the drafting stage of the type of claims that are statutorily established, and most people come in kind of understanding that the spouse gets half, but you want to be able to at least articulate some of the core principles behind the equalization process and the type of exposure you may or may not have should you decide to plan around a spouse, or even in conjunction with a spouse, but in a way that would not be economically reasonable.
So we just briefly talked about these common ones: repayment of loans, claims for debts, constructive and resulting trust. Let's just talk about sort of authority to litigate. And this is interesting because not that, to some degree it's a little bit unknown. And that is, how do you sue an estate? So if you're out there and you're representing a client who has a claim against a deceased person, how do you do that? Well, the first thing is, if the will has been probated, then you can sue the executor, and they have authority to defend that claim. But the little known one is the litigation administrator. And basically, the idea is that only an executor under a probated will has authority in court to represent the estate and to be bound by any decision of the court. And so that's why if you're suing, you want to sue an executor who's got probate. But what happens if you want to sue and there is no executor, or the executor has not received a certificate of appointment with respect to the estate? And that's what a litigation administrator, basically the plaintiff appoints or seeks the appointment of somebody to defend the claim on behalf of the estate. Typically, that's a situation where there's a will, the executor hasn't gotten probate yet, so you can't necessarily sue them, and they can bind the estate. So what you need to do is seek their appointment as a litigation administrator and to be able to defend the claim that your client is bringing. Ian, do you want to just touch on that at all, or maybe
I just so quickly on that point is that, like, this is a pretty technical point. I think the key, what I want to talk to my clients at the front end, is to say that it is actually very easy to sue an estate, and there are curative steps. The litigation administrator is one of them. Rule 7 is another, or 10, I forget what. One of the rules of practice allow it. You can name the estate of Bill Smith, and then later find out if they get probate. Later find out who the trustees are. But don't think that just because you've passed away that it's going to be a difficult lawsuit to pursue, is what I want to tell my clients, so that they understand that this is going to be, you can't bob and weave too much. They're going to get you pretty easily.
Right. And there are, of course, technical problems. The other idea is that there is authority in the Trustee Act that allows you to sue an estate for a wrong, right? So that's what we've highlighted here. So then let's talk about debts, and really the duty of an executor in respect of sort of common claims, debts against an estate. So, an executor has a duty to seek out and pay legitimate creditors, right? In a sense, the executor is a trustee for creditors who are owed money, almost like a bankruptcy trustee in the same sort of way. They have to pay legitimate claims. How do they find legitimate claims? One way is an advertisement for creditors. That's one of the reasons that's typically sought, is to find out if there are creditors, because that's going to protect the executor if they down the road distribute the estate, because they will have advertised, they've sought out potential creditors, which they have a duty to do. And that affords protection to the executor. If they distribute and nobody has notified them in response to the advertisement for creditors, then they're going to be protected. Ian, do you want to talk about that at all?
Well, I just think, again, that the whole, there really is no excuse for avoiding this important protection that you can obtain by doing the Notice Connect steps, for example, and protecting yourself from the personal liability that you're going to expose yourself to.
And as you can see, there's the personal liability of an executor who, where there's a potential claim, and if they distribute it, there's the personal liability, and there's typically a 2-year limitation period for suing an estate for a claim, and then we've got a special defense here, because think about the situation where you're ready to distribute after month 8 of the administration and you're ready to distribute, and you hear of a potential claim. Somebody writes you a letter saying, John Smith, the deceased, owed me $10,000. Okay. So you're sitting there and you know that there's a potential claim here. So what you can't do is you can't distribute the entire estate in face of that, or else risk personal liability. The limitation period hasn't expired yet because it's only month 8 after death. What do you do? And this is a special defense that's available to an estate. Ian, do you want to take us through the contestation?
Well, yeah, again, I mean, most of us on this call are not, deeply into the litigation. And so the steps in the contestation are very precise. They're set out by the statute. It's a summary process. And that is what it was established, quite frankly, early on as a tool for executors to move quickly on what were potential claims against the estate, and to allow them to address them in the manner that they have. And that's why you've got the precise steps, which again, we can go through, but it's not as important as is that you've got 30-day periods, and you've got ultimate protection because, for example, and it's a limitation, that period that is severely imposed, and that is that after the periods of time for the filings of the steps to be taken, if no claim is brought, if you say I'm testing your claim as executor by sending out the appropriate notice of contestation, and the plaintiff has 30 days to respond, and if no statement of claim is made, then they're forever barred. The case law has been pretty supportive of preserving that deadline. So that's why I say it's a summary fashion, but it's also a very powerful tool to clean out what might be some claims that are sniffing around the estate.
Right. Basically it's a way you all of a sudden you put the onus on the potential claimant, say, look, if you got a claim, you better bring it because I'm ready to distribute this estate. And that's why it's a special tool. In fact, where the potential defendant, the estate starts the litigation in essence.
That's right.
What about claims where there's a claim against a beneficiary? A beneficiary owes money to the estate. This is another special defense or claim, really, that estates have that pretty much no one else has. And this is the right of we typically call it a right of set off. So the beneficiary owes money to the estate. They say, well, I'm not paying or whatever else. The estate can withhold that amount from the distribution to that beneficiary. Now, here's the kicker. That potential claim, it doesn't necessarily have to be a legal claim, in the sense that if the limitation period has expired on the debt, this right of set off still applies. It's called the rule in Cherry and Boltby. And it's been around for, 100 years, more. And it's a little known rule again, but it's very important because even if a claim has, if the beneficiary said, well, I don't owe that money anymore, it's past 2 years, the rule in Cherry and Boltby says the executor has the right to set it off.
And you have to be so careful as an executor not to be dismissive of it either. So you have to make your proper investigation as to whether or not that's true. When someone says, oh, I paid mom off years ago, and the executor just says, oh, I believe you. Well, the other beneficiaries might not be so happy. And then you turn around and say, oh, well, it was outside the limitation period. All of a sudden, you're looking at a potential exposure.
And there's a lot of case law in Cherry and Boltby throughout Canada. So then let's just talk about, claims. This is a little bit technical, except that it's important because it's a very special defense. So let's say a claim is brought against the estate for, $1 million, and you're advising the executor, and you say, well, there's not enough money to pay that anyway. I don't even care. And so the problem is that there's a general rule that unless there's a special defense pleaded by the estate, it's assumed that the estate has enough money to satisfy a judgment on the claim and costs. So that, and the executor is personally liable if there isn't enough. So this is one that can catch an executor if they're involved in litigation. So it's really just a heads up that if the executor is ever sued and you're acting there, there's this plenty administrative that's a special kind of defense that says, I'm telling the plaintiff that we don't have enough money to satisfy that judgment. So just so you know, and that's from Commander Leasing case.
And of course, if you don't say it, you're exposed to personal liability. So again, as executor, I'm always wanting to make sure there's enough. I always say to my clients, we can't go below zero typically in estates. You either have what you've got and you defend it with whatever you've got. And if you hit zero, there's no more money, but you have to tell people that there's no more money.
Yeah. And the last sort of topic, and we're not going to get too much into the actual claims, but just from an estate point of view, I'm assuming that, we're here representing an estate, we're administering the estate, and, what do we have to worry about here on a dependent support claim?
Yeah, this is such an important consideration, especially at the drafting stage, because I want to make sure that the client understands who a dependent could be, and it's obviously a wide berth, so to speak. The definition is pretty clear, but having said that, people can fall into an independent adult. Children can fall into the category, and so on. But most importantly is the concept of a dependent relief claim is not often top of mind. If you've got even healthy adult children, but one is constantly being supported on the side, that in and of itself may have created a dependency, and that may affect your estate planning. So the dependent relief claims, I want to always walk through with the client. And then the second part of it, and it's a bit of an administration point, but as at the solicitor stage, is that when a client comes into me and sees me and says, look, I'm the surviving spouse, I'm the executor, I will want to send them to get independent legal advice as to whether or not they want to bring or need to bring a dependent support claim. Because if I'm acting for them in their capacity as executor, they have to think about the possibility that they indeed want to make a claim against the estate. And often, for my personal preferences is that the lawyer tells the surviving spouse, and often it's more than one of the executors as a surviving spouse. Often I'll say to them, the executors, look, the surviving spouse of the three of you, the surviving spouse needs to get ILA on this point and consider whether or not a dependent support claim needs to be made, notwithstanding the fact they were appointed executor. And it's a bit controversial, but it's in my view the safest route to go.
Let's just stay on that point for a second. What about a spouse comes in, there's a qualifying spousal trust, they're the sole trustee, for example. What do you think the right thing to do for the lawyer advising that person as far as their FLA rights?
Well, it seems to me that from my perspective, in exactly that scenario, I'd like to send them out to get ILA as to consider about what, if any, potential additional claims they have to make here. And a dependent support claim may be just one of them. Family law claims may be another. And if you're acting for them as executor, in their capacity of executor, they'd be suing themselves. So it's easier, of course, when there's more than one executor. But when it's the sole surviving spouse and she's the sole executor, I still like to get the independent legal advice issue addressed and front and center well within 6 months of date of death.
And now, do I have to, they come to me, I'm not acting, they said, oh, my husband died, I've been their lawyer all along. Can I give that advice about their family law act rights and their dependent support claim rights? And if they say, yeah, no, I understand. I knew this was going to happen, so I'm not going to make any kind of claim. I want it to go to the kids, for example, or whatever it might be. do you think, like, can you act in that situation if you haven't really started acting as, on the estate administration per se?
Well, it's a great question. And, these are kind of practice questions that bring out the reality of the day-to-day practice of law. Hard and fast rules don't work. They certainly don't work in a scenario like what you're describing. There are lots of good reasons why a spouse doesn't want to make additional claims, and you're not necessarily precluded to continue to act. It seems to me that you have to play it by ear, but depending on the facts. But if I've got someone coming in to say, look, there's lots of money in the spousal trust here. I'm going to live on it the rest of my life comfortably. I have no issue there. I respect my husband's wishes, or vice versa, and I'd like it to go this way. I don't think you're necessarily. That's a question of whether it is truly independent legal advice, which is a discussion for another day, and we should definitely have a seminar on that. But the point is that let's not be too roughshod over this and say that there's hard and fast rules. There just aren't, and it's not practical for me to say, oh, of course, you hear the word surviving spouse, you got to send them out for ILA and never see them again.
So I just wanted to talk a little bit about the executor, the executor's role, and the scenario is the executor comes in, you're acting, you know that there's a child out there who was receiving money support at the time of death. I think it's important that there is a de facto suspension of the executor's right to distribute in light of that within 6 months of the certificate of appointment. So the first point is that the limitation period for dependent support claims runs from probate, from the certificate of appointment, for 6 months. Why do they do that? Well, one of my theory is, why does it run from the certificate of appointment? Well, you need somebody to sue on a dependent support claim. And as I said at the beginning, the authority to be sued on behalf of an estate is a probated will. So, but we've got that 6 month period. Okay. Within that 6 month period, whether there's a claim brought or not, there is still potential liability if the executor distributes. Because if there's, and this is the Supreme Court of Canada talking, a possibility of an application, even without actual knowledge, then an executor distributes within that limitation period at his or her own peril. So that is important to know. Now, what our Act also says is that once an executor receives notice of an application, then there is actually a suspension, a legislative or statutory suspension of distribution, except for the support of dependents. But that's after an actual notice of an application is served. Which brings me to the point I'm going to ask you, Ian, about is, let's say, I know that there is this potential claim out there, and but the 6 month is ticking. I get to that six months and a day. No application for dependent support has been brought. I'm ready to distribute the estate. What are my options there? Or what do you think? What are some things that you're going to think about there?
Sure. Now, just in terms of the suspension, it suspends to the extent of the assets required to fulfill the claim, so to speak. So if you have a large estate and you've got lots of money, you can always continue to distribute in the face of an order in that sense. But and we're getting a bit technical, but I can tell you from a strategic standpoint, I have certainly had files where we have distributed 6 months and a day later all of the assets out of the estate. It makes it much harder to go beyond the 6 months. The Act says that you can get extensions, but it's in respect of the undistributed assets. So as an executor, you're actually pinned against the wall a little bit. You can't do anything for this first 6 months, nor should you. And quite frankly, I've never really understood why people move so quickly in the first 6 months with this a potential claim hanging over their head. But boy, 6 months in a day, you might be criticized for not having distributed. because you haven't exhausted the assets of the estate, and you've now left assets in the estate exposed to allow for the extension application. So it's a tightrope that you have to walk, and one that it's not commonly thought through for administrators and executors. I mean, and you can feel the brunt of the wrong side of that case if you haven't thought it through.
Yeah, and so I've cited that case, that Schwartz case, and I just caution people that even if you're negotiating, and this is more of a litigation thing, but as an estate trustees counsel, whether you're a litigator or not, and you know that there's a potential dependent support claim because you just got that feeling, that's something that we should be aware of as far as the strategy goes. There are cases where there was negotiation going on between the potential claimant and the estate trustee through the limitation period. No claim was brought, and the court said you can distribute in the face of that. So just be very careful in those situations, whether you're litigating or not. There's potential liability for the executor there.
That's great. Oh, Jordy, I apologize this week. I've just got to jump onto a pre-trial I've just got called back into. So I'm going to let you finish up with the questions.
Sure.
Okay, thanks.
Thanks, Ian. So the last point I just wanted to talk about is that in defending a claim, executors are entitled to defend and prosecute claims, and that's in fact their duty in many ways. But it's not a blank check, right? And so if they act reasonably and they spend reasonably on the prosecution or defense of a claim, then they're typically going to get reimbursed from the estate. The costs of that are going to come out of the estate, but not absolutely, and not if anything is judged as being unreasonable. It's not, you can't fight to the death again, a claim and spend the entire estate and then said, oh, well, too bad, sorry. So it's a tightrope, as Ian said. It puts the executor in a difficult position because they want to defend it, claim, let's say, to secure the estate and maximize it for the beneficiaries, but it's not unlimited. And so consent from the beneficiaries would be helpful, because and say, look, I'm just telling you, do you want us to keep going on this in defending it or prosecuting it? Because you're not necessarily going to get all those costs back. So I just wanted to make that last point. And again, this is a higher level thing, but it is things that cross our desk, whether you're a litigator or not, when you're acting on an estate. So just to field a couple of questions here in our final minutes. Certainly releases, there was a question about a notice of contestation versus a release. If you get a release from a potential claimant, that's certainly sufficient in my view. The way to draft a will to exclude a dependent support claim, I'm not sure, there isn't a full, a complete bar to a dependent support claim. You can make you can make things more difficult for a claimant. For example, you could say, look, you get X dollars, but if you seek dependent support, we withdraw that amount. I'm not sure a court's going to love that. If they're close enough to being a dependent, court's going to take that into account. But it is similar to a person challenging the will. But even a domestic agreement, a marriage contract or a cohabitation agreement, or even a separation agreement doesn't necessarily bar a dependent support claim. So with that, I just wanted to thank everybody for being here. And we're looking forward to seeing you again next week. And have a great, safe week, everyone. Thanks again. Bye-bye.